I received another question on my social media recently asking whether or not the court will consider domestic violence when making orders for custody. And the answer is absolutely. If there's any evidence of that, it would be really important for you to bring that to the court's attention. The overarching legal standard for the court when assessing custody cases is what is in the child's best interest. Now, there are certain factors that speak to a child's best interest. One of those statutory factors in Arizona is whether or not domestic violence and or child abuse has occurred. So if there is an allegation of domestic violence, the first thing that the court must analyze is whether domestic violence occurred. There are certain factors that are enumerated in Arizona's statutes that the court can rely on to determine whether domestic violence has occurred. To help the court determine whether domestic violence has occurred, they can look at findings from another court. Maybe there's a criminal charge in domestic violence, in which case you would use that criminal charge in your family court case. They can look at police reports. They can look at medical reports. If there's child abuse, they can look at any records from the Department of Child Safety. If you sought shelter at a domestic violence shelter, then you can use those records, school records, testimony, really anything that you have to support that domestic violence has occurred. Now, the next step, if the court has found that domestic violence has occurred, Arizona law says if there is a finding of domestic violence or a history of significant domestic violence, then it would be contrary to the child's best interest for the parent who committed domestic violence to have joint legal decision making. Joint legal decision making refers to the power to make decisions on behalf of your child. Medical decisions, educational decisions. Arizona law essentially says if you have committed domestic violence, it does not have to be against your child, but if you have committed domestic violence, and we do not think it is in the child's best interest for you to have the legal authority to make those decisions, and will typically award higher authority or more authority to the other parent. However, the third step is what we call a rebuttable presumption, because Arizona also has in its statutes law that says if the parent can overcome the presumption that joint legal decision making is not in your child's best interest because you have committed domestic violence, then they may still consider ordering joint legal decision making. What that means is that if you are the parent who has committed domestic violence, you may be able to overcome that presumption that you should not have joint legal decision making if you can rebut it. How does a parent rebut the domestic violence presumption? You essentially have to argue to the court that despite the domestic violence finding, it would still be in your child's best interest to have joint legal decision making or equal parenting time. The court can also look at whether or not the abuser has completed any domestic violence courses, battery prevention program, if they've completed any alcohol or drug abuse counseling that may have led to the abuse, if they've completed any other parenting classes that might help rehabilitate and inform the abuser as to why that was not in their child's best interest. They're also going to look at whether or not this is the first instance of the abuser's domestic violence, or if there's any other acts of domestic violence that have been committed. They can also look at whether or not the abuser is on parole, if they're completing community service, if there's any history of orders of protection. That's all stuff that they have to consider, because it's going to determine or help them determine what would be in your child's best interest. And the answers to those questions and factors may impact their joint legal decision making order. So they need to know that before they make it. So if there has been a domestic violence history or an incident of domestic violence, it is very important to raise that in your case and provide to your attorney, if you have one, or to the court, all of the evidence that you may have to support that allegation, so that they can determine, after analyzing everything, whether or not it would really be in your child's best interest to have joint legal decision making for both parties.